So today I wanted to talk to you about how to make sense of your termination paperwork. So unless you've only ever been in one job your entire life, you know that the pink slip is a myth. When you resign or are laid off, you actually get a stack of paperwork. If your employer's doing it right, there should probably be a fair number of pieces of paper. If they're doing it on a shoestring, maybe they're not giving you all the paperwork you're supposed to have. So some of this might be about actually going to get the paperwork that you need. The basic piece of paper that everyone should have is essentially like a termination notice or termination letter. The termination notice usually says you're being terminated effective this date. That document is helpful for knowing when your termination date is for your last paycheck and also for applying for unemployment insurance. It should also say your final paycheck is enclosed, and depending on the state you're in, the paycheck may also include any accrued but unused vacation. Typically, state law will say when you have to send people their final paycheck. And in some states, it's the very last day of your employment. In other places, it's the next regular payday. In other places, it's like, a certain period of time, like a week. So if you don't have your final paycheck, you could expect to get it soon. The other big piece of paperwork that you can usually expect to get, again, it depends on state law, is something called unemployment notice. And the purpose of that is not to tell you that you're eligible or not, because the state unemployment division determines whether you're eligible. State unemployment notice, it just shows you how to apply for unemployment insurance. And so hopefully it has a website that you can go to apply that hasn't crashed. Or sometimes you can apply over the telephone. Applying in person is probably not a great idea right now. You might see a separation and a release agreement. So if your employer is in a position to pay you severance, usually that severance is going to be contingent on signing a document called a separation agreement and release. And that document will release all claims against the company that you might ever have or that you currently have. If you think you might have to sue the company in the future, for example, they retaliated against you for complaining about illegal activity at the company, or they retaliated against you for labor organizing, or who knows, they didn't pay you all of your wages, talk to a lawyer before signing that. Typically, the amount of severance they give people is not going to be very much. 2 weeks of severance. And so if you really think you have a valid claim against the company, it might not be worth it to sign that. Otherwise, if you have no intention of suing them, you can go ahead and sign it. The way it works is, if you're under 40, typically, the agreement will be effective when you sign it and return it to the company, and you can expect your severance soon thereafter. If you're 40 or older, that document's going to include a release of your age discrimination claims, and so that typically won't be effective until 7 days after you've signed it. So if you're 40 or older, you're not going to get your severance check until later. If you need more time to consider a separation and release agreement, you can always ask the company for more time. The termination notice should have the date that they want you to make a decision by, but if you really need to think about it, or you're not sure, or you want to talk to a lawyer, ask them if you can have more time. Generally, they want you to sign it, and it's not going to hurt them at all to wait a little bit more. There's another thing that you can expect to get called COBRA Notice. COBRA Notice is a document that tells you your rights under, I don't know what, it's called COBRA stands for something. So that notice says, if you have employer health insurance, that notice says that you have the option to continue your health care coverage if you want, but you have to pay the employer premiums. And that can be quite expensive. That is one option for continuing your healthcare coverage. I would also look into other options before you decide, and you have a little bit of time on whether to elect COBRA, and hopefully you should get information on when you have to decide and when you need to make those premium payments. But you may find that the Obamacare marketplace is cheaper than what your employer is currently paying, or it's possible you'd be eligible for Medicaid. I think that's it. Oh, one other thing, if you're it's cold. If you sign a confidentiality agreement at the start of your job, or maybe you sign a non-compete, you may also get another copy of that document as part of the termination packet. That is just intended to remind you of your pre-existing obligations under that document. You don't have to sign anything. And one thing to know is that not all those provisions of that document are necessarily enforceable if state law has changed. For example, if you were laid off and you had a non-compete, in some states, non-competes are unenforceable if you get laid off through no fault of your own. Or, for example, maybe there's been some Me Too laws that have passed in a state and that allow you to talk about discrimination or harassment, and the contract doesn't include a carve-out for that. Or maybe the law has changed on non-solicitation of former employees. They're giving you that document because they want you to abide by it, but if you're unsure whether a particular provision applies to you, you can look up whether the state law has changed on that topic before you get all worried about being sued by your former employer.